21-173-185. This is Franklin River Apartments LLC versus Chanel Smith. Matters before the court set on for a motion hearing, sounding in a motion to set aside a default that was entered in this matter. Your appearance for Franklin River Apartments, please.
Good morning, Your Honor. Denise Baker, P53670, appearing on behalf of plaintiff.
Thank you, counsel, and good morning to you. I am looking now for Chanel Smith. If you're on the Zoom, please say something at this time.
Good morning, Judge.
All right, good morning to you, ma'am. I do see that a judgment was entered in this matter by default on the 6th of July, 2022 for $2,181.25. That judgment was entered secondary to the fact that the court received proof of service and that there was no response filed to the complaint in this matter. So tell me why you believe that the default judgment should be set aside in this matter.
As I stated in the attachment, I had lost my fiance, which was a pretty traumatic event for me. And, you know, it just I wasn't paying attention to the mail as I should have. And that's my reason for good cause for failure to answer. And then for my defense, I did request validation of debt from Franklin River or their representative on 2 different occasions. And according to 15 USC, they did not fully comply with all of the requirements in proving that validation or verification of debt.
All right, ma'am. So when did you, and I'm sorry to hear so, and I know that it's documented in your motion. When did you lose your significant other, ma'am?
He passed in November 2021.
And you share children together or a child?
Yes, we have a 2 and a 4-year-old, and I found him home deceased with them as I work midnights. So, you know, it's just pretty hard to deal with that, and you know, just not paying attention like I should have to the mail and things like that.
Well, that certainly would be, those would certainly be traumatic events. I lost my spouse some years ago with children. So yeah, I understand some implications here. All right, let me hear from the other side regarding this matter. Ms. Baker, you've had a chance to go over the motion. I believe that I saw something might have been responsive. Talk to me at this time, your thoughts.
Your Honor, the defendant was personally served on January 29th of 2022. She did send in a letter on March 18th, and we requested to that validation of debt request. A default was entered against her on July 7th, as she did not file an answer to the complaint. This is her 3rd time she has filed a motion to set aside the default. The first time the motion to set aside default was denied on June 21st of 2022. The second time the motion to set aside default was denied on July 5th of 2022. As both times she has not presented a meritorious defense to this lawsuit. And we are maintaining again that there is no meritorious defense filed, no affidavit in support of any defense as to the balance owing under the lease agreement. And we request the motion be denied.
All right, thank you, counsel. So Ms. Smith, anything further you wanted to bring to my attention this time? As you correctly identified, there are 2 things that you have to establish by way of trying to get the judgment set aside, and that is number 1, that there is a good cause for not responding timely to the complaint, and certainly the issues that you have presented would establish good cause as to why you may not have responded timely to the complaint, given the loss of your significant other and father of the children. Obviously, that was a dramatic event, and that would give rise to not responding in a timely fashion. The second prong that the court has to look to is whether or not there is an affidavit demonstrating a meritorious defense. While I do not see an affidavit attached to your answer. On previous occasions, I believe that you've attached something in the nature of an affidavit. But I guess my concern is whether or not this presents a meritorious defense. If what you're saying is that the defense that you have to the claim is that debt was not validated under the provisions of the UCC, that lack of validation, if I take it on its face, does not vitiate or does not eliminate the debt or the obligation. If, however, you have something that is a defense to the underlying debt, or you have some factual scenario that you wish to raise to challenge the fact that you're being sued for this debt, then you need to bring that to my attention.
Yes.
Go ahead, ma'am. I'm listening to you.
And what I submitted to the courts, the attachment to the motion and affidavit to set aside, number 6, pursuant to the U.S. Code 1692I, the absent the validation of the said claim within 20 days, the debt collector must cease and desist any and all collection activity and prohibit it from contacting me via mail, telephone, person, at my home or work. And that is defined in the law as well. So my defense is because they didn't fully comply with validation of debt within 20 days, that they cease and desist this case because they failed to comply with the law.
There is nothing about the statute that does not allow them to bring a claim before the court for the matter to be validated by this court as to whether or not they have a cause of action against you. The USC site that you indicate is that to the extent that there is a lack of compliance in that regard, then the person holding the debt could not continuously make phone calls to you, send letters to you, et cetera, outside of the court setting to try and collect a debt from you in that regard. That does not prevent them from coming to court to advance their claim that there is any indebtedness. Before I make my determination, Ms. Baker, anything you wanted to say about that particular prong? Because obviously the ban that this court has before it in terms of stretching to see if there is something here. If there is a valid defense, does not mean that that the plaintiff or defendant wins or loses. It simply means that there was something to litigate. And I don't believe that if the only thing that she's raising is that the debt was not validated on the UCC by paperwork being sent to her upon her request, that vitiates the right of the plaintiff to come to court to seek a hearing to have a determination as to whether that debt is a debt that should be the obligation of the defendant. Counsel.
Yes, Your Honor. Again, the defendant has not raised any issues as to why she does not owe the underlying debt. And if we wanted to address the validation request, again, we received a letter from her on March 18th of 2022. We sent her 45 pages of documents on March 30th of 2022, and there was no other telephone contact with her at that point. Again, as you stated, that does not prevent us from moving forward with our litigation. And again, she has not addressed the underlying debt in this hearing as to why she does not owe the funds.
All right, you get the last word, Ms. Smith. It's your motion.
Well, I'm just going to continue to, use the law of the the Fair Debt Collection Practices Act, and I do understand what you're saying, Judge, as well as Ms. Baker. So I'll allow the judge to continue for.
All right, ma'am. All right, thank you. Thank you very much, ma'am. All right, I've listened to the argument on the motion here. Certainly, defendant meets the criteria as it relates to the first prong of the law for setting aside a default judgment. She certainly been able to demonstrate good cause for not responding in a timely manner. But she also has to show that there was a meritorious defense to the claim. And the issues raised regarding the validation of debt notice under UCC, Uniform Commercial Code, et cetera, those do not give rise to the court being able to conclude that the plaintiff could not proceed by bringing to court a debt that is alleged against the defendant for purposes of having that issue determined by the court. And for that reason, I don't see that there is a valid defense. I guess a part of what the court was looking for is a claim that the amount or that the judgment that was entered in this matter related to a dispute regarding rent or something along those lines, and that the defendant was disputing whether or not she actually owes those amounts because she did not believe that they were properly assessed against her, and she wanted to contest that. That would sound in the nature of a presenting perhaps of something that might be a meritorious defense that I don't owe the debt. They're charging me for something that I shouldn't be charged with. None of that has been alleged in either occasion when the motion has been brought. And this is the third time for the motion being brought, and it's never been alleged that there is a contest of the debt except for the assertion of the claim under the UCC. The claim under the UCC does not rise to the level of being a meritorious defense to this claim. If the court found everything alleged as a violation of UCC, it would not mean that the plaintiff could not bring this action to court. It may mean that the plaintiff could not call or send letters to the home to pursue the debt pre-judgment or pre-court, but it would not prevent the plaintiff from coming to court and advancing their claim in front of this court. For that reason, I don't find a valid defense, and therefore the motion fails on the second prong, and therefore the motion has to be denied. That is my order at this time. I do wish you well, ma'am, and I can't imagine a more difficult place to raise young children to deal with untimely death like that. I do wish you all the best going forward. Good day to you. Thank you, Counsel. Good day to you.
Your Honor, one more minor matter. Would the court be willing to enter this denial with prejudice since this is the third time she has brought this motion?
I'm not willing to do that, but a fourth motion would obviously result in the assessment of cost by the court. You know, we hate to get to those kind of things, but that's what would happen. So the motion will be denied as indicated, and any other motions on this issue would be the court will assess costs and present presentation of any other motion.
Thank you, Your Honor.
Good day to both sides.
Thank you.
The court now calls case number 21-171728. This is Logical Property Management versus Latoya Williams. The matter is before the court on a motion for reinstatement and for entry of default regarding this matter. The record should reflect the matter was the matter was dismissed. I think that had to do with a administrative determination of no progress. Your appearance at this time for Logical, please.
Good morning, Your Honor. Hamzi Sob on behalf of Logical Property Management, P82080.
All right, thank you. Thank you, Counsel. Good morning to you, sir. Do I have Latoya Williams on the Zoom? If you're here, please say something at this time, or any counsel for Ms. Williams. Again, I'm looking for Latoya Williams, living on Sussex Street in the city of Detroit. The record should reflect that the court did send a notice to the address provided on Sussex Street on the 28th of July 2022, setting this date on as a date for hearing regarding a motion for entry of default and for reinstatement of the case. Counsel, it doesn't appear that the defendant has appeared on this matter. Why do you believe this case should be reinstated in default intercirculation?
Oh, well, Your Honor, it was dismissed for lack of service on June 15th of 2022, but we submitted an affidavit of service that indicated that service was effectuated on the first day of April 2022, 11:12 a.m. And we also motioned the court for alternate order to submit that service, and we posted by attaching the order regarding alternate service, and the second summons is complete on that day to the 15080 Sussex Street address. We'll motion the court for reinstatement based on the fact that it was dismissed for lack of service, but service was effectuated prior to the dismissal date.
All right, I reviewed the file and I do see where there was the court granted the order of alternate service that allowed for services complained by first-class mail and also by other means. I see that on the 31st of March of 2022 that there was first-class mail service. I also see that on April 1st, I have an affidavit of service indicating that the defendant will serve the complaint, the summons of complaint in a conspicuous place on the property. That would be sufficient notice in regard to this matter. I will reinstate the matter as requested at this time. Again, the court gave notice to Ms. Williams, even of this particular court date, to be here to raise any issues that she might want to raise at this time. Having failed to do so, the case will now stand reinstated, and the motion for entry of default judgment for default and default judgment will be granted at this time. The court will find the defendant is in default and failure to reply to the service that was made on the 31st of March, as well as on April 1st of 2022. And the failure to do so means that she has not acted timely in this matter before. Default is she is in default and judgment will be entered upon that default. Counsel, you want to submit the order? You have the email address to send the order to me.
I will, Your Honor. Thank you.
You have the email address. Are you ready for it?
For the court, yes, I do. For the clerk, yeah.
All right, real good. So get that order to me right away, and we'll sign it, and that'll close this file out. Right, good day to you,
We'll
sir.
do, Your Honor. Thank you.
The court now calls case number 22-184195. This is Midland Credit Management versus Christiana. It appears Poor is the last name, P-O-R-E. The matter is before the court settled for a hearing on today's day. It looks like this is the first hearing after receiving an answer to the complaint. That answer was submitted to the court on the 26th of July. Your appearance for the plaintiff Midland Credit Management, please.
Good morning, Your Honor. It's Craig Fay, Beat 81401.
Thank you, Mr. Fay, and good morning to you, sir. Do I have Ms. Pori on this Zoom?
Yes,
Say
it's-
something. Tell me your name.
Christiana Poor.
Go ahead, Ms. Pori. Tell me your name. Say your name, please.
Yes, it's Christiana Poor.
All right. Thank you, Ms. Pori. All right. Good morning to you, ma'am. I did receive your answer regarding this matter, and I know that you and Mr. Fay have had an opportunity to speak earlier today. I'm gonna ask Mr. Fay update the, regarding this matter. Go ahead, Mr. Fay.
Sure, we did have a discussion in the breakout room. A offer was proposed. We're gonna submit that to the client. And then we should have an answer within the next couple of days. So I'm not sure if the court would just wanted to, I guess, reschedule the status conference, or the court wants to issue a pretrial order to keep the case moving. Either way will work, but we should have a response to Ms. Poor within the next couple of days.
All right, so what I'm going to do is I'll go ahead and set it over and for a review in just a few weeks, just to see if the party's been able to come together with this. If not, then I'll go ahead and set up some type of scheduling order at that time. So I'm going to put it a couple weeks out, 2-3 weeks out. Bring it back.
October 31st.
October 31st. October 31st, I'll review it on that date. And if the parties have been able to resolve it, then that'll be fine. If not, I will look towards setting up some type of schedule so the parties can get information and events to explore. You understand that, Ms. Moore?
Yes, I understand.
All right. So that's going to be 10/31/22, and I'm going to set that at 9:30 a.m. And I look forward to seeing the two of you on that date at that time. Good day to the two of you.
Thank you, Your Honor.
Thank you.